Hi everyone, I'm Linda Loveland here with Jake Parker, General Counsel for the North Carolina Farm Bureau, and we have a lot to talk about because we had a big win. And this is talking about general permits and the Department of Environmental Quality, a case that went to the North Carolina Court of Appeals. So we got a big win on this.
We did. It's always good to talk to you after a win.
Yes.
And this is a case that's been around since 2019. It involves the state's animal waste permits. So there are certain farms in the state, swine farms, certain cattle operations, dairies, egg-laying operations that have to have a non-pollution permit from the state of North Carolina. We have been involved in the case for a long time, and it deals with really the Administrative Procedure Act of North Carolina, which is one of my favorite things to talk about.
That sounds really exciting, the Administrative Procedure Act. And it's really all about rulemaking and how that's done, essentially, right?
Yep.
So, not to get too much into the weeds on this, but how this all started, it all sort of surrounds three rules, right? Or in the permits.
Yep,
Make sure
three conditions that are in the permits. The permit is a long document. It's about 20 pages. It has 90 conditions in it. And these are things that farmers who hold these permits or certificates of coverage is the technical term under these permits that they have to do. And so there were three of them that we had real concerns about because of the way that they were put into the general permit. And the Department of Environmental Quality issues a general permit every 5 years. So the story really dates back to 2014 when that version of the permit was being discussed. Some groups who oppose the way that it's primarily about swine and hog farms, the way that we do the spray and lagoon fields or spray field and lagoon system in North Carolina. They had some concerns with the permit, and instead of taking their concerns to the administrative court in North Carolina, they filed what we call a Title VI complaint, a civil rights complaint with the Environmental Protection Agency. To make a really long story short, the department and these two groups sat down and negotiated a draft permit without farmers in the room and then presented that as the discussion starting point.
So they didn't involve all the groups, they didn't go through the normal procedures, essentially.
Correct.
Circumvented all of that.
That's right. And so then there were, out of that, in our view, there were more than three, but there were three that we were really worried about that were contained in that permit, and that's what we went to litigate against.
So essentially you said that's not fair how this came about.
Correct.
You've got to go through the right procedures and the right rules and all this, so you took them to court.
Yep, and that's what the Administrative Procedure Act does, Linda. It protects procedural rights, and it's about fairness and making sure that everybody has a chance to weigh in on a particular issue. Doesn't mean you're going to get the result you want, but you at least get the chance to make your case to the agency.
And if you're affected by it, if that's your livelihood, I mean, obviously you should have a say in how that goes.
Correct, that's right. So we took the case to administrative court where we won, and what happened there was the judge concluded those three conditions are rules under the Administrative Procedure Act. And a rule, to keep the definition simple, is a regulation, a standard, or a statement of general applicability that implements a bill that the General Assembly or Congress hasn't acted. We argued that those three conditions that they were rules and they hadn't been adopted under the APA's rulemaking process, so they needed to be blocked. The administrative court agreed with us. We then went to a superior court, Wake County Superior Court, and the judge there disagreed with us. And then we had to go to the Court of Appeals, and they just agreed with us.
So a big win. So now we're hearing that maybe some of these groups who oppose these or who wanted these rules in place, I guess what's the future? What does that mean moving ahead? Is there going to be are we going to be back in court for this?
Well, the processes we're getting familiar with is you have an appeal to the North Carolina Supreme Court or the U.S. Supreme Court. In this case, it's North Carolina because it's a state law matter. Yeah. And that's a discretionary matter. So we call them petitions for discretionary review in state court. So the other side, the Department of Environmental Quality, the environmental groups that are against us in the litigation, they may file a petition with the North Carolina Supreme Court. They we'll respond, and then it's up to the court whether, again, do they want to take the case or not. We hope that this one they don't want to take.
So, I mean, what's the end point? I mean, how long does this keep going? Do we keep going about how can it finally come to an end and it be resolved, I guess?
Well, when the court tells, we don't really know the way the timeline would play out. The other side has until mid-December to decide whether they want to appeal. Then we have a very short window to respond. And then it's up to the judges on the Supreme Court how long it takes them to get through the case.
Okay.
So,
and that would be the final.
Yeah, and then we'll brief it if we have to go. If they agree with us that they don't want to take the case, the justices on the state Supreme Court, then we're done. The case is over. If they do decide to take the case, then we got to go through briefing and an oral argument and all those things. What's interesting about this, though, is there's also a renewal of the now what we call the 24 general permits. It's ongoing. So this case is very much in the discussion as to what does the 24 version of the permit look like? Is it going to contain these three conditions? We hope it doesn't. We've asked the agency not to include it because the courts concluded that they're rules, so they shouldn't be in there. So let's just take them out. But we don't know what the agency is going to do. We'll have to wait and see.
A lot is up in the air, but in the meantime, we'll just take the win.
Absolutely. It's been a good thing for our farmer members because they haven't had to implement these really onerous conditions. They deal with groundwater monitoring, testing their farms for phosphorus levels, and filing an annual report that contains information about their farms that can be made publicly available upon request. So we've been able to hold those things off over the last 4 years, and that's been a really good thing. I just hope we can get some resolution and make some good law along the way.
All right. Well, thanks for all your work and for everything that really, I mean, the Farm Bureau legal team has done an incredible job. I know you guys spend a lot of late nights working on this for the farmers, so it's paid off.
Well, they're definitely worth it. And again, it's always good to be talking to you on a win.
For sure. All right. Thanks, Jake.